Have you ever pulled an envelope out of your mailbox, seen that incredibly official Internal Revenue Service logo sitting right there in the corner, and just felt your heart rate instantly spike? Honestly, it's a universally relatable moment of pure anxiety. But what actually happens if you just shove that envelope into a drawer and ignore it? Well, today we're going to confront that exact tax anxiety head-on by shining a light on the actual step-by-step mechanisms of IRS collections. Welcome to this explainer. I was digging into this topic recently, and today we're going to completely demystify the intimidating IRS collection process together. We're talking about the real-world escalation arc. From that very first moment you miss a payment, all the way to the most severe enforcement actions the agency can take. But more importantly, we're going to decode all that confusing jargon, break down actual notice documents, and figure out exactly how everyday people can finally take back control. Okay, let's dive right into this. Here's our roadmap for today. Number 1, the IRS paper trail. Number 2, liens versus levies. 3, inside notice CP504. 4, your right to appeal. And finally, number 5, resolving your tax debt. Starting with Section 1, the IRS paper trail. You know, the absolute biggest misconception out there is that the IRS operates like some sort of rogue debt collector, just immediately freezing your bank accounts the exact second you miss a deadline. But in reality, the paper trail is highly sequential. It's like a staircase. It almost always begins with what's called a CP14. That's just your standard initial balance due notice. Now, if you ignore that, the tone gets, well, slightly more urgent, with CP501 and CP503 reminder notices. If you keep up the silence, that triggers a CP504, which is a warning of an intent to levy certain assets, like a state tax refund. Finally, if you still don't respond, you hit the absolute most critical stage, the LT11 or Letter 1058. That's the final notice of intent to levy. I really want you to take a breath here because our source material spells this out perfectly. The IRS does not jump straight to garnishments or levies. There is almost always a paper trail first. The entire system is actually designed to give taxpayers multiple, distinct opportunities to respond and resolve the issue long before any enforced collection begins. Early action is quite literally everything, because with every single letter you ignore, your options shrink and the consequences get a whole lot heavier. Which brings us to Section 2, liens versus levies. As that paperwork escalates, you are going to see these two L words constantly. And yeah, they sound incredibly intimidating. People actually mistakenly use them interchangeably all the time. But legally speaking, they represent two totally different stages of the collections process. So the crucial point here is understanding the exact distinction. A federal tax lien is essentially just a piece of paper. It's a legal claim against your property that protects the government's interest. It's basically telling other creditors, hey, the IRS is first in line if this person sells their house, but it doesn't physically take anything from you today. A levy, on the other hand, that is the actual physical taking. A levy is when the IRS legally seizes your bank account, garnishes your wages, or takes your property to satisfy the debt. So just remember, lien equals a claim, levy equals taking. Now, even if the situation deteriorates all the way to a levy, there are still boundaries. The IRS absolutely cannot take your unemployment benefits, they can't take your workers' compensation, or necessary school books and clothing. They also can't touch a specific, calculated minimum amount of weekly exempt income. Basically, they cannot legally leave you without the fundamental means to survive. Moving on to Section 3, inside notice CP504. Okay, when a taxpayer finally opens a CP504 notice, that's usually when the panic sets in. Right at the top, bold as day, it plainly states, Notice of intent to seize, levy your property or rights to property. The language is incredibly urgent. It's telling you flat out that they intend to levy your state tax refund or other assets to apply to what you owe. It's totally designed to get your attention, and honestly, it usually works. To put this into a real-world perspective, our example notice shows an immediate balance due of $9,533.53. But here is the crucial takeaway. Ignoring those earlier letters actively inflated this number. The original tax owed in this example was just over $9,400. But because time passed, a failure to pay penalty and interest charges were tacked right on. Literally every month you ignore the problem, the IRS assesses a 0.5% penalty plus a variable interest rate. Silence literally costs you money. But here is the massive sigh of relief when it comes to the CP504. Despite that super scary header, the IRS cannot levy the vast majority of your assets with just this notice alone.
Now, yes, they absolutely can grab your state tax refund with it, but for your actual wages, your bank accounts, or your car, they must first issue a formal final notice of intent to levy. So, CP504 is a severe warning for sure, but it is not the end of the line.
If we look deeper into the fine print of the notice, we find the countdown clock. It explicitly states that if they don't receive the amount due within 30 days from the date of the notice, they can move forward. This 30-day window, that is your golden opportunity. It's your time frame to respond, pick up the phone, set up a payment arrangements, or exercise your legal rights before any real damage happens.
Let's talk about those rights in Section 4, your right to appeal.
So it turns out you actually have two main avenues to fight back: the Collection Due Process, or CDP, and the Collection Appeals Program, or CAP. CDP is really the heavy hitter here. You use Form 12153, and you usually have a strict 30-day window to file it after receiving a final levy notice. And here's why that's huge. Filing a CDP pauses the 10-year collection clock, stops levies dead in their tracks, and if you disagree with the outcome, you can actually take the IRS to tax court. The CAP program is broader and generally faster, but the catch is you don't get to go to tax court if you lose. Now, your appeal rights aren't exactly a secret, but they are buried deep in the paperwork. Right there in the fine print on page 3 of the CP504, it outlines your right to request an appeal under the Collection Appeals Program within 30 days. And this is exactly why you cannot ignore these letters. If you let that 30-day deadline slip by, you legally forfeit these incredibly powerful appeal rights, and the IRS essentially gets a green light to levy. There is one massive myth we need to bust about appeals, though. An appeal is not a magical do-over for your tax return. As the IRS explicitly states, in a CDP hearing, you can only discuss the actual amount you owe under very limited circumstances, usually only if you never had a prior opportunity to dispute it. So what is the hearing actually for? Well, it's for discussing collection alternatives. It's your chance to sit down and say, okay, I agree I owe this, but levying my bank account will completely ruin me. Here is my alternative plan. Which leads us perfectly into Section 5, resolving your tax debt. How do everyday taxpayers actually settle these terrifying accounts and get back to sleeping soundly? Well, here are the 3 primary lifelines. First up, installment agreements. If you can't pay it all today, the IRS will generally let you break the debt into manageable monthly chunks over time. Second, the offer in compromise. If paying the full debt would cause severe economic hardship, you can petition to literally settle the debt for less than you actually owe. And third, the currently not collectible status. If you genuinely cannot afford to pay anything right now without starving or losing your home, the IRS can officially pause collections until your financial situation actually improves. And hey, here is a fascinating and honestly pretty surprising fact about the system. The IRS cannot chase you forever. By law, they generally have 10 years to collect an assessed tax debt. This is known as the collection statute expiration date. Now, keep in mind, actually this is super important, certain actions you take, like filing for bankruptcy or requesting a CDP appeal, can hit the pause button on this 10-year clock. But the core truth remains the same. The debt does have a legal expiration date. If there is one ultimate takeaway from all the material we've explored today, it's summarized perfectly right here. Ignoring IRS notices does not make the problem go away. Resolving the issue often becomes more expensive. Every single day you delay, those penalties stack up, the interest compounds, and your legal windows to appeal slam firmly shut. Early action is absolutely your ultimate shield against actual asset seizure. So, I'll leave you with this final provocative thought. Knowing exactly how predictable this escalation arc actually is, and knowing that real lifelines and appeal rights exist right now, is ignoring the IRS truly worth the risk to your wages, your bank accounts, and your peace of mind? Or is it finally time to open that envelope, read the timeline, and take back control of your financial future? Thank you so much for joining me on this explainer. And remember, when it comes to the IRS, knowledge is absolutely your best defense.